Senate Judiciary Committee will come to order. We have two senators, Senator Ossoff of Georgia, Senator Tillis of North Carolina, who will do their 30 minutes of questioning to complete the agenda from yesterday. And then each senator will be allowed 20 minutes to ask questions if they wish, but the chair is more than anxious to entertain efforts to yield back your time. I'm sure that the witness, Judge Jackson, would appreciate it as much as all of us in that respect. I'm going to make an opening statement. Senator Grassley is going to do the same, and then we will proceed with the questions by the two senators. First, I would say, Judge Jackson, that I thought that President Biden got it right yesterday. He tuned in and watched the proceedings and said you showed both grace and dignity. I've used the phrase grace under pressure, and it's been referred to by many people. This is a tough assignment, and many have risen to the challenge, but none as well as you did yesterday. Thank you for doing it so much. I would just say this, much of what we heard from a handful of senators yesterday has to be put in context. The overwhelming majority of senators on both sides, I thought, were asking appropriate questions and positive in their approach and respectful of the nominee before us. But for many of senators, yesterday was an opportunity to showcase talking points for the November election. For example, all Democrats are soft on crime, therefore this nominee must be soft on crime. Well, you've made a mess of their stereotype. The endorsement of the Fraternal Order of Police, the International Association of Chiefs of Police, just doesn't fit with their stereotype of a Harvard grad, black woman who is aspiring to the highest court in the land. But you earned it. Law enforcement is on your side because you've been on their side at critical moments. And your family has dedicated a big part of their lives to law enforcement, and you obviously believe it at your core. You said that over and over again. So the soft on crime charge, which leads all others, falls on its face. The second thing is that you are somehow out of the mainstream when it comes to child pornography cases. And of course, that gets down to the question of sentencing and your choices in sentencing. It is difficult, if not impossible, for each of us to put ourselves in your place when you are facing all the totality of facts concerning a certain defendant, then looking at your requirements under the law as enacted by Congress and trying to do the right thing to keep America safe, but to meet justice. You are in the same place as 80% of federal judges when it comes to sentencing on child pornography cases. 80%. And of course, Congress is not without fault. We have failed to pick up the responsibility that was assigned to us some 17 years ago when the Supreme Court decided that the basic guidelines would not be mandatory on judges. We should have stepped in at that point. But it's a tough, hard, controversial subject, and we've stayed away from it. And what has happened is the judges have tried to make do with a fractured situation where they have guidelines that are advisory, they have opinions coming to them about sentencing from the government, as well as from probation office and others. So I would say that the bottom line is this. You have done what 80% of the judges have done. You're in the mainstream of sentencing when it comes to child pornography cases. I also think it's ironic that the senator from Missouri who unleashed this discredited attack refuses to acknowledge that his own choice for federal judge in the Eastern District of Missouri has done exactly what you did. You also have been criticized as having been wrong to be a public defender or even to be in a law firm representing a Guantanamo detainee. It's interesting that Republican judges, very conservative ones, don't see this as a blemish on your character. They understand, as we do, that the Sixth Amendment creates a responsibility that people have a right to counsel. You have exercised that responsibility in your professional life. This, incidentally, yesterday, your nomination turned out to be a testing ground for conspiracy theories and culture war theories. The more bizarre the charges against you and your family, the more I understand the social media scoreboard lit up yesterday. I'm sorry that we have to go through this. These are not theories that are in the mainstream of America. but they have been presented here as such. Finally, you are a respected, successful woman of color. You've been approved 3 times by this committee for increasingly significant judicial assignments. Now the President of the United States has chosen you to serve on the highest court of the land. America is ready for this Supreme Court glass ceiling to finally shatter. And you, Judge Ketanji Brown Jackson, are the person to do it. Senator Grassley.
Mr. Chairman.
Yes.
Mr. Chairman, I think you've, in the main, provided both sides an opportunity to be heard and ask their questions. But unfortunately, I noticed that after every series of questioning on this side of the aisle, you choose to editorialize and contradict the points being made by this side of the aisle. I don't know whether we will have an equal opportunity to editorialize about the advocacy that you and your colleagues, the points that you're trying to make. I especially was concerned that after my questioning yesterday, I left the hearing room and you chose to come back after a break and raise with the judge a point that I had asked her about, and which I frankly think was misrepresenting my position and what the facts are with regard to whether the judge has accused President George W. Bush and Donald Rumsfeld of war crimes. My language was, I asked her whether she'd called them a war criminal, and she said under oath to you, no, I did not, although the record is plain as it can be that she accused them of war crimes. Now, I don't understand the difference between calling somebody a war criminal and accusing them of war crimes. Maybe in some other foreign language that I don't frankly understand, maybe that would make sense, but not in accordance with a common understanding of the English language. So I just want to lodge a protest and say that I don't think it's appropriate for the chairman, after every time somebody on this side of the aisle asks questions of the judge, you come back and you denigrate and you attack and you criticize the line of questioning. I think the judge is doing a pretty good job of defending her own position and answering questions. So thank you for giving me a chance to express my objection to the way that you've been editorializing after each time this side of the aisle asks questions.
Thanks, Senator
Mr. Chairman.
Excuse
Mr.
me.
Chairman.
Excuse me. Thanks, Senator Cornyn. It's known as chairman's time.
Could I make my statement first?
You want to make your statement?
Yeah.
Well, may I respond to what Senator Cornyn said?
Well, if you want to speak before you're a
May I?
ranking member,
Thank you.
Tyler, you're right.
Mr. Chairman, I agree with Senator Cornyn. You and I have talked about this before. I have great respect for you. You know that. But I've had the same issue in normal hearings, non-Supreme Court hearings, where you make editorial comments after I question. I appreciate your input, but they're not offered in an even-handed way. And I just don't think it's productive. I mean, you just referred by name to Senator Hawley. I think he should have a chance to respond. You know, this is America. We have the right to express ourselves. You know, you're not free if you can't say what you think. And I want to join my colleague, Senator Cornyn. I just don't think it's appropriate, Mr. Chairman.
It's called chairman's time. It is a tradition in this committee exercised by Senator Lindsey Graham as chairman and Senator Grassley in previous Supreme Court.
But they didn't do it the way you do it,
I'm
Mr.
going
Chairman.
to allow you to be heard, but I want to be heard
Of course.
without interruption.
Of course.
And so in the minority, we waited through chairman's time when we had Republican chairs. There will not be a separate set of rules for Democrats in control of this committee. That was used as a response time and again by both of those senators, and it was accepted. If what I said was somehow problematic or painful yesterday, I'm sorry, but the Democrats are going to use the same mechanisms that the Republicans have used in this committee.
And I appreciate that, Mr. Chairman. But I think if you're going to personalize it as to senators by name, you ought to give them a chance to respond.
Well, they will have a chance.
Mr. Chairman?
Each and every senator has 20 minutes today to respond if they wish.
Mr. Chairman?
Who's seeking? Senator Ossoff?
Could we hear from Ranking Member Grassley, and then I'd like the opportunity to ask questions on behalf of the state of Georgia. I think the American public is now tuning into these proceedings expecting a substantive discussion of matters of grave importance to the country with a nominee for the Supreme Court before us. I don't think we've set an appropriate tone by bickering over time and process at the outset of our proceedings. Every senator deserves to be heard. I would like to humbly request that Ranking Member Grassley make a statement, that I and Senator Tillis have our opportunity to question the nominee, and that then we can litigate balls and strikes from yesterday's hearing. Would that be acceptable to the committee?
I think in the name of your humility, we should do that.
Thank you, Mr. Chairman.